Left is Judge Leslie Schultz-Ken, who we are pleased to have with us, sitting by designation from the 13th Judicial Circuit. And to my right is our Chief Judge, Daniel Traver. We will go ahead and get started with the first case, which is 23-4030, Phyllis Bursey v. American Traditions Insurance Company. Counsel for Appellant, please introduce yourself and let me know how much rebuttal time you'd like.
Thank you, Judge. May it please the court, my name is Chad Barr. If I could have 5 minutes for rebuttal, I'd appreciate that.
Thank you, Mr. Barr. Go ahead.
I think you picked the right case to start with this morning. We have a short briefs and a very narrow legal issue to get the day of oral argument going. We're here today asking the court to reverse the trial court's final order dismissing Ms. Bursey's breach of contract claim. As I mentioned, the issue in this case is very narrow. It's whether the trial court erred when it dismissed Ms. Bursey's lawsuit based on its conclusion that the lawsuit was premature, based solely on the language in the policy, and by disregarding the language found in 627.70, 70152.
Yeah, I'll start this off, and maybe it's just going to give your colleague a chance to think about it before it's his turn. But, you know, to me, it seems like a pretty straightforward statutory analysis, and it's cabined in my mind by the Florida Supreme Court case law that says that when we have a statutory amendment, that we look at policy language within the confines of that controlling precedent. So you've got a situation where the statute is amended before the policy is issued, and the statute pretty clearly seems to say that this suit could be filed when it was filed. Now, whether the suit has any merit might be a separate issue entirely, but it seems, if I'm looking at the plain language of the statute, that it allows your client to do what she did. Do you disagree with any of that?
I don't disagree with that. And I think it's important to understand, and it kind of segues into my first point, was the argument that the appellees are making here today is a merits-based argument. And what they made below was a procedure-based argument. And even under tipsy coachman, it doesn't work here because there's no record or evidence to support the argument that they're making for this, asking this court to affirm based on an entirely separate grounds. The argument that they made below and the fact that they're changing it now actually supports what the commentary that you just made about the statute's interplay with the policy. The argument below was that 627.70152 didn't apply at all. It didn't apply. They went so far as to even make the claim that they didn't ask for appraisal pursuant to the statute when that's controverted by the evidence in this case. The record demonstrates their second demand for appraisal said they were demanding appraisal pursuant to the statute. So the argument that they made below that the statute doesn't apply was the entire basis for the court's argument, or the court's conclusion, excuse me.
Well, it seems to me not just the court's conclusion, but the court's disposition, which is going to be a dismissal without prejudice, but requiring a new complaint to be filed.
Correct.
Which effectively jurisdictionally for us is
final.
Right. So if you've got and I noted the change in argument from below to here, and I do applaud the candor, frankly.
Yes.
But the effect of that would seem to me that if the argument that was made on appeal was made below, it would be a dismissal without prejudice for leave to amend. And the other thing that kind of struck me was the idea that by the time that dismissal order was entered, the 60 days had run in terms of the time to pay out under the policy. So I think I appreciate what you're saying on two levels. Number one, I appreciate it in the sense that it would be a different disposition, seemingly. And then secondly, it would be a distinction without a difference because you wouldn't have the factual predicate that was being made before us because the 60 days would have run.
Right. And so there's a couple of other issues too. And I think, kind of an overarching one, and one that wasn't addressed below because that wasn't the posture of the argument, but was whether or not the 90-day provision in the statute is a 90-day deadline to complete appraisal. What's interesting is I know this court has conflict with the Cole versus United or Universal Property and Casualty as it relates to retroactive application of statute. But the court, the fourth DCA said in that case that the insurance company has 90 days to complete appraisal. So there's an additional question of whether or not appraisal was waived by them not completing it. There's an issue of whether or not they breached the appraisal provision by requiring a release. They attempted to require a release in April. Ms. Burzy to sign a release in order to get the appraisal funds. There's all these circulating issues that weren't dealt with below, and they need to be dealt with. And summary judgment issues probably, but they need to raise the affirmative defense, and we need to file replies, and it needs to be litigated on the merits.
Mr. Barr, my question is, given that you were not given leave to amend, to give you relief here, do we need to decide that you have any claims left, or is it simply enough for us to say it was error to dismiss with no leave to amend, and just leave it to you to amend if you've got something or not? In other words, do we need to say that you have claims left?
I don't think you do, because that wasn't what the trial court wasn't given the opportunity to decide that issue. I think we go back. They made some important statements below, which I think the court should key in on. At the hearing, in their response to our motion for rehearing, they said plaintiff would like us to be operating under the appraisal provision within 627705152 because that would justify the filing of the lawsuit. We don't really need to go any farther. They were admitting below that if we were operating under 627705152, the lawsuit was authorized, and now here on appeal they're saying the statute does apply. So,
aren't you just looking for a vacator of the dismissal?
Yes, and to proceed on the lawsuit that was filed.
Right,
and
and you might have fee issues out there. I'd ask you too. There's a motion from your colleague as it relates to the lawsuit being frivolous. It seems to me that would be fair game as well.
Right.
Okay.
I agree. And that wasn't ruled on either. And as it relates to the fees, I found it a little humorous that they were making this white knight argument in their answer brief. We have to remember some things about this case. They offered to pay less than a third of what the arbitration actually awarded. They refused to pay the arbitration award for 8 months. The arbitration award was in January. They didn't pay it till September. They forced Ms. Burzy into appraisal. They didn't complete appraisal within 90 days. And they want to make this whole argument in their answer brief about attorney's fees. Well, 6277015, this is not a 627.428 case where we just get fees no matter what. There's a steps that we have to take, and there's an award that has to be made in order for us to even be entitled to attorney's fees. So for them to be arguing that this is some nefarious act by our client to get attorney's fees, we were authorized to file a suit within 90 days, after 90 days, and that's what we did. We waited 105 days and then filed the lawsuit. It's up to them to raise the affirmative defense and for us to litigate the merits of the case. Judge Strebe, you keyed in on a lot of the arguments that I was going to make. I don't want to waste the court's time this morning. If there's no other questions, I'll have a seat. And
Good morning.
Good morning.
Court. My name is David Burr, and I represent American Traditions Insurance Company. I'd like to follow on to the question of the argument below as compared to the argument on appeal. It has always been American Traditions' position that filing this lawsuit during appraisal reflects that a cause of action didn't exist at the time the lawsuit was filed.
Counsel, wouldn't the cause of action had simply been failure to pay under the policy terms? I mean, we understand that appraisal was going on, but it wasn't completed. So as of that point in time, 90 days past the beginning of the appraisal, we had an insurer who still hadn't received payment under the insurance policy. So doesn't that at least provide a good faith basis for a breach of contract cause of action, understanding that maybe the remedy will come through appraisal, but they didn't have it yet?
I'll avoid the good faith question, but the answer would be no, they would not have a cause of action for breach because Your Honor, what you're describing is a disagreement about the amount of loss. And under the policy...
It could be coverage, though, couldn't it? Like, if the argument is going to be my roof leaks and you're refusing to pay me for it, isn't that the basis of the claim? I mean, appraisal is a statutorily created feature. And certainly there's a different argument that y'all have here as opposed to below about what the effect of that statute is. But I think it's just this lady's roof is leaking and the insurance company isn't paying to fix it.
It's specifically, and the parties agree on this, specifically as appellant's trial counsel acknowledged in the hearing below, American Tradition's obligation was to pay an appraisal award. The problem is at the time the lawsuit was filed, there wasn't an appraisal award. So that obligation that the parties agreed was the obligation hadn't ripened, let alone had it been breached. And
Are you saying at this point, are you going back to what your client was arguing below? And I recognize that you weren't the lawyer who made that argument, but are you going back to what your client argued below, which is that the statute doesn't apply because the policy controls?
No.
Okay. So if you're on the appellate argument that under the policy's language, the time to pay out the award hadn't happened yet, how is that justification for a dismissal of the lawsuit and a directive that it would need to be refiled under another case number? Why wouldn't it just be a dismissal to leave with leave for to amend, when that 60 days to pay under the policy had run, which by the way, it had by the time the trial court issued the order?
Correct, it had. The reason comes back to the fact that there wasn't a cause of action at the time the lawsuit was filed. And so that goes back to Voges. Florida Supreme Court tells us the general rule, and I don't want to misquote it, I have here, is that the right of a plaintiff to recover must be measured by the facts as they exist when the suit was instituted. So the appraisal award was not a fact. The running of the 60 days was not a fact. So none of those give a basis to the lawsuit that was filed.
So you're getting to the lawsuit's merit, right?
Yes.
Which theoretically would have been the subject of the sanctions motion that was filed below.
Yes.
And it seems to me that your colleague properly just conceded that if y'all want to fight about what the lawsuit's merit was at the time of filing, you can do it if we reverse this and vacate the dismissal. I don't understand the magic of making them refile under a different case number when you're effectively, and I get you don't have an appellate burden, but you're effectively conceding that the statute controlled in this particular context. And they could file the lawsuit. The statute says, I can file the lawsuit. You're saying, well, you might be able to, but I disagree that it has merit. That seems to be, to me, a much more of a substantive type defense that you would just address via affirmative defense or sanctions motion.
So there's a couple of points to raise in response to that. The first is definitely these factual matters are often raised or ordinarily raised, either in a judgment on the pleadings or motion for summary judgment, but in any event, after an answer, right? However, American Traditions filed a motion to dismiss, and on appeal, the question of whether that was the appropriate vehicle wasn't raised in the initial brief. So that's not a question that would be dispositive on appeal because that wasn't submitted for this court's review.
Help me understand that, because the way that I read the initial brief was the trial court erred when it dismissed the lawsuit without prejudice, but having to file a different lawsuit because the case was prematurely filed under the policies language. In other words, yeah, I mean, so how is there a appellate presentment issue when that's the declaration as to why the trial court erred? And it seems to me, I don't want to put words in your mouth, but it seems to me that you're conceding that on those grounds, they're correct. What you're saying, I think, is we should affirm anyway because the lawsuit has no substantive merit.
I'm saying two things. They are challenging not the vehicle that are in the initial brief, but the decision. And the decision is correct that if the lawsuit is using the word premature under the policy because the appraisal hadn't been completed, that shows that the trial court's decision was correct because the cause of action doesn't exist. And if I may draw the court's attention to a brief point in the record, during the hearing below, Judge Schreiber posed a question to appellant's trial counsel. I'm assuming this insurance contract has the standard requirement that the appraisal is a precondition to filing of a lawsuit. Am I right on that? And the response was, you are correct, Your Honor. So there's no dispute that that is a condition of filing the lawsuit. The court found that because the appraisal had not concluded, it was premature and dismissed it.
But the statute, which predates the issuance of the policy, says that you can sue after a set time period that everybody agrees it run.
But that does not mean that a cause of action had ripened. It simply means that you would not have the defense of this is premature under the statute. But
How do we read that language, though, other than to say that you can sue? Like, it doesn't, if that view is correct, then how could anyone ever, how could a insured ever take advantage of that statutory amendment by filing a lawsuit when appraisal hadn't completed yet?
Anyways, the 90 days is a period in which the parties ostensibly are working together with the appraisers. And remember, this isn't limited to appraisal. That provision says appraisal or alternative dispute resolution. So say, for example, the appraisers can't agree on an umpire. Well, the policy says you can petition the court to choose that. If there's a question about the impartiality, whether the umpire is disinterested, whether there's competency concerns, those can be submitted to the trial court. If someone's not communicating, if there are scheduling concerns, there's any number of reasons to petition the court. But in all of those cases, what you're asking the court to do is to help facilitate the conclusion of appraisal. It is not creating a mechanism by which you nullify the appraisal process and send the claim to litigation. That's exactly the opposite of what the statute is trying to do. And if we think about it, why would this statute require pre-suit notice? In other words, say you can't file a lawsuit, not yet. You have to give the insurance company a chance to respond. And explicitly, one of the ways they can respond, if it's a covered claim, is they can request appraisal. And so the statute is promoting appraisal. It's also promoting the opportunity to re-inspect if it's a denied claim, settlement,
Isn't it
mediation.
potentially also promoting fast appraisal?
Not exactly, Your Honor, to be honest, because keep in mind, this appraisal took 6 months. Imagine if we had a 15-building apartment complex. The idea that the legislature was contemplating that appraisals will normally, let alone always, be completed in 90 days certainly is not supported by my experience, though I know that's not relevant. But it's just not consistent with the way appraisal goes. It's much more consistent with the rest of the language of the policy, that the purpose of the 90 days is to provide a vehicle so that claims don't get trapped in limbo in the appraisal process. Right.
Now, I understand your argument, but could theoretically the legislature have put in different appraisal timeframes based on the size of the project if it wanted to do so?
It could, but I would say they did not put in any time frame for appraisal. This is a time frame for when a lawsuit can be filed without immediately filed without additional notice. But it does not somehow certainly doesn't say, but it also doesn't imply that we would like to therefore nullify appraisal, all of the 90 days of time and expense that you guys have poured into it, goodbye, go to litigation. It's not generating litigation, this statute, but that's what this interpretation would do, and that would yield an absurd result. You'd have not only the wasted time of appraisal, you would incentivize delay.
Counsel, why does filing a lawsuit necessarily conclude the appraisal? Why can't they proceed on parallel tracks?
Well, if one has a cause of action, then perhaps they could. But if what you are attempting to plead is breach of contract and an element of that cause of action hasn't occurred yet, then you don't have an existing cause of action. And the law is clear about that. Each element has to exist and have occurred. But if what you want is payment of an appraisal award, at a minimum, you have to have the appraisal award. We didn't. So they did not have that cause of action. If they had petitioned the court, let's say there was a disagreement, they said, American Traditions, your appraiser doesn't know what they're doing. Your appraiser somehow has a conflict. And there's a dispute over that. You can petition the court to resolve that, but you're facilitating, you're not taking it off of the appraisal track.
Counsel, as I read the statute, the notice requirement is it applies to the insured when the insured has a claim under the policy. So before the insured can sue on that claim, the insured must give notice. And then the insurance company has some options for responding. But if the response is, let's go to appraisal, then when you read it all the way through, it gets to the end and say the appraisal isn't completed in 90 days, then the insured can file suit without doing anything else. It seems like when you read these provisions together, as we must, it's always talking about the claim under the policy. In other words, the statutory language doesn't say you can file suit if it concerns the appraisal process or the disinterest, whatever. If it concerns some aspect of the appraisal specifically, the statute doesn't limit the suit that can be filed to that. And in fact, I think when you read it all together, it's talking about the same suit that the insured wanted to file but had to provide notice before filing at the very beginning. Can't the legislature have said we only want the lawsuit to be something concerning the appraisal process itself, not the claim under the policy, if it wanted to say that?
I suppose it could have said that, but I don't think it needs to say that to mean that. Because it wouldn't mean that if you have no cause of action, no longer is that a basis to dismiss your lawsuit, because we've blessed it by the expiration of 90 days after appraisal. The expiration of 90 days does not give rise to a cause of action. To your point, Judge Ganim, if they do have a cause of action, then they can file suit after 90 days. But when appraisal is the fact pattern, and the policy says that the amount of loss payable is determined based on the amount of loss, and that the amount of loss is determined by appraisal, then it will be the case that when the lawsuit is filed, assuming appraisal has not been completed, that neither party knows what the amount owed is. And let's keep in mind, they also don't know whether anything is owed. It is entirely possible that appraisal comes back at a number that is equal to or less than the insurance company has already paid, in which case they would not owe anything additional. But they certainly would not have breached that obligation. Not when you look at the facts as they exist at the time the lawsuit is filed. The time the lawsuit is filed, you have an ongoing appraisal and no appraisal award. There cannot have been a breach of the payment obligation that the parties agree is determined by the award, which does not exist at the time. And if I may add one more point. This question of leave to amend was not argued again also in the initial brief. And that's understandable, although they made that argument in the trial court. It's understandable that they would have abandoned it here because an amendment doesn't cure the non-existence of a cause of action.
Wouldn't that request have just been futile though, based on the trial court's ruling? Trial court's basically just saying, look, I'm not saying that you can't pursue this claim. I'm just saying you can't pursue it under this case number. It's effectively a dismissal with prejudice. So how could, yeah.
So I appreciate that point. And what we are not saying, in fact, I would say the opposite, is that we would have some sort of res judicata argument if they had filed another lawsuit based on the facts that unfolded during this lawsuit, such as the expiration of the 60 days. We wouldn't have said, oh, that's res judicata, because that's entirely inconsistent. It's the opposite of what we're saying here today, which is that, no, you cannot bring that cause of action. And so here, by amendment, you cannot do that. So we also would not say in that second case, res judicata, you could have brought that in the original lawsuit, because that's not our position, and that will not be our position.
Because of something you said, a dismissal is for a failure to state the cause of action. It seems to me like amendment is precisely the way that you fix that problem. But even beyond that, by the time the complaint was dismissed here, there had been an appraisal award and there had not been payment within the deadline imposed by the statute, by the contract. In other words, it was late no matter how we look at it. Why couldn't the insured at that point have amended the complaint to state that, well, my cause of action is failure to pay the award? I mean, amendments happen all the time, and claims change over the evolution of a lawsuit.
Yeah, I mean, absolutely. Litigants reserve the right to pick their battles and so forth. But the law in Florida is that if you have no cause of action, not that you don't state one, it doesn't exist. At the time you file your lawsuit, amending doesn't cure that. That's not an available remedy.
Did the trial court decide that amendment would be futile because there is no possible way to plead a cause of action here? Or did they just say that the trial court just conclude that one wasn't stated yet?
The trial court concluded that they had filed the lawsuit prematurely because appraisal had not been completed. That was what the trial court's order said, and I cross-checked it to the hearing transcript, and it's very similar. But that would mean that the cause of action doesn't exist. There would be nothing to meritoriously state, hence the 5715 motion.
Which you could still litigate on.
We could. And if that's meritorious, I don't think that should be advocated for by appellant. And we're certainly not on appeal advocating for that outcome. We would ask the court to affirm, finding that dismissal was proper because having no cause of action, which the record establishes, is a ground to dismiss a lawsuit. Whether leave to amend should have been granted is not before the court because it wasn't briefed initially.
Thank you, counsel. Any more
Thank you.
questions? Thank you.
Just real briefly, I want to make just 3 points in rebuttal. One, we have to rely on the plain language of the statute. The statute, as Judge Agam pointed out, the statute doesn't say what you can file a suit for. It just says when you can file a suit. And we complied with the statute. In terms of this, the bulk of the conversation from Appellee's counsel was about a cause of action. Cause of action is determined by looking at the pleadings, taking those pleadings as true as alleged. The trial court was required to do that and didn't. So we alleged a contract, we alleged a breach, and we alleged damages in our complaint. How those come about and what they look like down the road is the subject of substantive motions, not a procedural motion at the motion to dismiss stage. And lastly, their argument below was nothing more than Miss Bursey didn't comply with her condition precedent to allow the appraisal to complete itself. And they have to agree that that's wrong, because 627-70152 applies. It sets a deadline for concluding appraisal. That didn't happen. That gave, admittedly, they admit below that gives rise to the lawsuit. So we would ask the court to reverse.
Counsel, help me understand, the argument has been made that the cause of action didn't exist yet because appraisal wasn't over. So is completion of appraisal, is it right to look at that as a condition precedent to the cause of action, or is it simply a forum selection for one part of the dispute? In other words, if it's coverage, that goes to court. If it's the amount of loss, that goes to appraisal. Is it accurate that the cause of action itself depends on completion of appraisal, or does the breach of contract action exist independently of the appraisal being completed?
Yeah, I think our position would be that the appraisal was either waived or not timely completed, or some defect with respect to the appraisal. Their argument was that you have to let it play out in order for you to file, because their policy says you can't file a lawsuit until appraisal has been completed. The statute says you can file a lawsuit if appraisal hasn't been completed in 90 days. So arguably condition precedent, but we complied with it because we waited the 90 days.
If you filed the lawsuit after the 90 days, and the appraisal is not yet completed, does the insured still have a duty to participate in that appraisal through completion, or at some point, or at what point is the insured excused from having to do that anymore?
I think it comes down to what's happening in that appraisal. I think in this case, Ms. Bursey, there's no dispute that she complied with the conditions of appraisal. Where it turns is when they don't pay for 8 months, when 3 months after the appraisal, they try and force her to sign a release, which, by the way, would have waived her right to interest, would have waived her right to supplemental claims, to reopen claims, all those things which are not required of the policy. And then there's the issue of whether they properly paid all the interest, whether it relates to the date of the appraisal, whether it relates to the date of the claim was reported. None of those things were resolved. And so I think it depends on how the case takes shape as it progresses. But is it a condition precedent? That was our argument. My position is they could raise that as an affirmative defense, which would then give us the opportunity to file a reply to it. And again, it's a whole concept of avoiding cause of action by an affirmative defense, avoiding an affirmative defense by a reply. Those are all available avenues in this particular case. So if there's no other questions. Thank you. We would ask the court to reverse. Thank you. Happy holidays.
Likewise.